Welcome to Huddleston Bolin. Today we'll be featuring Scott Sheets, a partner in the firm's Huntington, West Virginia office. Scott's practice is focused on employment law and labor management relations. The focus of today's presentation is who is and who is not protected as an employee.
Let's talk about who is and who is not protected as an employee. Most of you are familiar with not only the federal anti-discrimination statute, commonly referred to as Title VII, but also the state's version thereof, the West Virginia Human Rights Act. These statutes protect employees and job applicants on the basis of their age, race, sex, disability, gender, religion. There are some other federal statutes at play as well, including the Americans with Disabilities Act and the Age Discrimination and Employment Act. But the general focus of all these statutes is to prevent employers from discriminating against employees based upon certain characteristics that they hold. Changes have been occurring, however, in the area of civil rights laws, and some states have already adopted statutes making sexual orientation another protected category. West Virginia, however, does not recognize sexual orientation as a protected category, and neither does the federal law. Interestingly, the city of Huntington just last month adopted a change to their ordinance, their human relations ordinance, adding sexual orientation as a protected category. What this means for employers in Huntington is that your employees now have a potential claim against you if you discriminate against them on the basis of sexual orientation. This is such a recent change that there aren't any complaints that I'm aware of that have been filed, and it'll be interesting to see how the Human Rights Commission of the city handles these complaints. But in any event, it's something that employers need to be aware of. Another change that is occurring in the category of protected status is marriage. We've seen across the nation various states adopting, either by the legislative process or by court order, changes to their definitions of marriage to no longer mean just marriage between men and women, but also same-sex marriage. In West Virginia, we do not recognize same-sex marriage, although it's important to note, however, that there is currently pending before the United States District Court for the Southern District of West Virginia a case filed by several gay couples claiming that they have been discriminated against and that their rights have been violated because they were not permitted to marry. There's an Equal Protection Clause argument at issue, and we're waiting for Judge Chambers to make a decision on the matter that's pending before him. That could be some time, but it's something that employers need to watch for in West Virginia. Now, what about these employers in states that already recognize same-sex marriage? How does that affect them? Well, with the United States Supreme Court decision last summer striking down parts of the Defense of Marriage Act, it now means in states that recognize same-sex marriage that employers have to extend certain benefits to these employees that they may not otherwise have extended. For example, Family Medical Leave Act must now be extended if a same-sex employee needs it in order to care for a seriously ill spouse. These employees get to file joint tax returns in states that recognize same-sex marriage, whereas in states such as West Virginia they cannot. In other words, we've got a patchwork quilt developing across the country, and West Virginia employers, while not directly affected, need to be cognizant of the fact that change is occurring and very well could come to this state.
Thank you for joining us for this informative video. Please don't hesitate to contact us at Huddleston Bolin for more information or to discuss your legal needs.